I'm Robert Muse, co-founder and senior counsel of the American Freedom Law Center. Today I want to address the critics of one of our primary public policy initiatives, American Laws for American Courts, or ALAC. My colleague and fellow co-founder of the American Freedom Law Center, David Yerushalmi, is the author of the model legislation known as ALAC, so we know a thing or two about it, unlike most of its critics, such as Joe Carter, who wrote about the dangers of anti-Sharia laws in the Gospel Coalition blog. From reading his blog, there's little doubt that Mr. Carter has good intentions. However, his good intentions do not make up for his lack of understanding. Then there are the critics from the Council on American Islamic Relations, or CAIR, a Muslim Brotherhood Hamas front group operating here in the United States. And while CAIR is certainly ill-informed when it comes to ALAC, CAIR's intentions are no doubt nefarious. So let me address here the criticisms often advanced by both groups, the ill-informed with good intentions and the ill-informed with evil in mind. The criticism typically attempts to mischaracterize ALAC by turning it into a caricature. Thus, the grossest form of this argument claims that ALAC prohibits the recognition of religious law tribunals adjudicating matters between religious disputants as a private arbitration panel. A more subtle but still blunted form of this argument characterizes ALAC as a law that prohibits the application of all foreign laws or the enforcement of foreign judgments in state courts, whether religious law or secular law. None of these characters are correct. ALAC precludes the state courts from giving effect to foreign laws or foreign judgments only when the application of those foreign laws or foreign judgments would deprive a party in a state court of a constitutional right or liberty. The operative language of ALAC provides that the foreign law is unenforceable only if its application to the litigation at hand would actually or foreseeably deny a party's constitutional rights. In other words, a state court might very well apply Sharia, or the law of England, as courts do all the time in the appropriate circumstances. For example, the parties agree to such laws in a contract. As long as the particular aspect of Sharia or the law of England applied in the matter at issue does not undermine our own state and federal constitutions in the case being adjudicated. ALAC is agnostic about whether the foreign law is a religious law or secular foreign law. Opponents of ALAC typically mischaracterize ALAC in an effort to drag it into a dispute with Jewish law and Catholic canon law, presumably to enlist Jewish and Catholic opponents to ALAC. But there is literally no instance of Jewish law or Catholic canon law being applied in a state court where a litigant is likely to be deprived of a constitutional liberty. And the reason this is so is because neither of these religious laws occupy the space of authoritative state law. Sharia is problematic precisely because it is the secular law in almost all of the Muslim world, either as a law of the land simply, or as the authoritative law in matters of family relations and citizenship, or what is sometimes referred to as identity law in those Muslim countries which require their citizens to declare a religious affiliation for their identity cards, such that the law treats Muslim citizens differently from non-Muslims. But even assuming there were such an occasion where a party ran into a state court and sought to enforce a Jewish court or Christian or Catholic ecclesiastical ruling which violated a party's constitutional liberties, why should any state court grant such a ruling state approval, which in turn triggers the police power of enforcement? The proper response should be that if the two religious adherents wish to submit their disputes to a religious tribunal, then fine. And like any arbitrable award, the winning party may use the state court to enforce that ruling, but only if that ruling accords with our fundamental constitutional liberties. State courts ought not be in the business of using the state's police power to enforce laws that violate our constitutional rights. Moreover, U.S. constitutional law already prohibits any state law from infringing on what the courts have determined to be legitimate applications of religious freedom. Thus, if a church dispute erupts and lands in a state court, the abstention doctrine announced by our U.S. Supreme Court precludes a state court from intervening unless that intervention is based on a dispute that can be resolved on wholly secular, religiously neutral grounds. In other words, religious arbitral bodies are constitutionally protected when they apply religious laws to purely ecclesiastical disputes, and ALAC may not, as a matter of First Amendment law, apply. The next type of attack on ALAC is not actually a criticism of ALAC per se, but a poorly constructed argument that ALAC is not necessary. And this argument typically begins by assaulting the presumed motivations of the law as anti-Muslim. This attack is sometimes presented in more nuanced form by trying to argue that Sharia is not what it is throughout the Muslim world. That is a religious, political, military body of law that requires death or beatings for blasphemy, so no freedom of speech, and apostasy, so no freedom of religion, and which demands a world ruled by Islamists pursuant to Sharia. This argument then asserts that the illicit motive of ALAC is the fear of creeping Sharia. Well, yes and no. ALAC understands there is a growing problem in state and federal courts of transnationalism, or the globalization of both politics and law. In other words, ALAC is a legitimate protection of the United States Constitution and prohibits foreign law and foreign judgments from usurping our constitutionally guaranteed liberties. Indeed, ALAC's critics are either not aware of or purposely avoid the Speech Act, which was passed by Congress and signed by the President in 2010. The Speech Act was in reality a kind of federal ALAC, but limited to the First Amendment and free speech rights. It was necessitated by the fact that authors, researchers, and publishers who published facts about the financing and sponsoring of jihad from the golden tents of Saudi Arabia, Qatar, and Dubai would find that they had been sued in England, where the libel laws are so liberal they permit the suppression of free speech that would never pass muster in the U.S. But once the offended plaintiffs obtained a judgment in England, they would travel to the U.S. and find a state court to grant the judgment comity, turning the plaintiff into a judgment creditor, who could now use the police power of the state to have the sheriff physically enforce the judgment. The practice was so prevalent and dangerous, it became known as libel tourism. In response, Congress passed the Speech Act, which, like ALAC, prohibited granting those judgments comity if they did not provide the protections of our own First Amendment. And why was this necessary? Because state courts were not sure how to deal with this problem of transnationalism. Well, all state courts have adopted the common law doctrine of void as against public policy, a doctrine which allows a court to ignore a foreign law or judgment that might otherwise be given effect if that foreign law is repugnant to the public policy of the state. Courts were not sure what the public policy was or should be. And this lack of clarity was built into the void as against public policy doctrine because courts did not want to be in the business of legislating public policy limits. Indeed, in every state you can find appellate court decisions making clear that the state legislature must define the parameters of what is the state public policy. Thus, courts should only tepidly step into this arena. ALAC takes up this judicial invitation to have the legislature make clear that any foreign law, religious or secular, that violates a party's constitutional liberties is void as a matter of public policy. ALAC critics typically attempt to make this point of not necessary by claiming that the few well-known cases they know about have been overturned on appeal, such as the trial judge in New Jersey who held that a woman could not obtain a restraining order preventing her husband from raping her because the poor man was simply following his cultural norms, that is, Sharia. But this ignores the study published by the Center for Security Policy, of which my colleague is also general counsel, that tracked 50 cases of this sort. Now, any lawyer will tell you that if there are 50 published opinions from the appellate courts, there'll be hundreds of cases just like the New Jersey case, where the judge applied Sharia over U.S. law that are never published or appealed because the losing party simply didn't have the wherewithal to fight the court's ruling. But the typical response to the brute facts cited in these published cases is to pretend that this tip of the iceberg is little more than an ice cube melting away on a hot sidewalk outside a single court in a single state. But those are not the facts. So it is that ALAC's critics ignore an appellate court decision from Maryland, also cited in the Center for Security Policy study, where the court enforced the Pakistani Sharia court's judgment of custody in favor of the father, even though the mother had argued that she was not provided due process because had she gone to Pakistan to contest the case, she could have been subject to capital punishment. Yes, a fancy legal term for death, for having a new relationship with a man not sanctioned by Sharia. In other words, the Maryland appellate court ruled that since the woman could not prove she would be executed had she gone to Pakistan to litigate custody in the Pakistan Sharia court, which is a national state court in Pakistan, her failure to go to Pakistan and take the risk of execution precluded her from making the void as against public policy argument. No doubt ALAC would have provided the Maryland appellate court the legislative clarity to have reversed the lower court's outrageous decision. In short, ALAC's critics argue that ALAC is unnecessary by simply ignoring the real world and the real lives being destroyed by the application of Sharia and other constitutionally offensive laws in state courts every day. Indeed, after these critics tell us that Sharia is nothing to worry about, and further that ALAC simply does what the law does anyway, both false assertions, they argue that ALAC will undermine our national security by alienating peaceful Muslims. How does a law that protects constitutional liberties alienate peaceful Muslims? Especially a law that is not specifically directed towards religious law, but only constitutionally offensive foreign laws. In short, it doesn't. The remainder of the typical assault on ALAC is to attack its proponents on purely ad hominem grounds, as religious bigots and the like. But even assuming these slanders were true, which they are not, what does that say about the law itself? Nothing. Finally, and for the record, the Oklahoma Constitutional Amendment, which was challenged the day it was enacted and enjoined by a federal court from being formally adopted because it was likely unconstitutional, is substantively and procedurally unlike ALAC. And by way of a footnote, my colleague counseled the proponents of this constitutional amendment against going forward with it for the very reasons as to why it was struck down. Yet ALAC's critics never failed to lump the Oklahoma effort with legislation that passed in Kansas, Tennessee, Arizona, Louisiana, among other states, all modeled after ALAC. The earliest of these laws have been on the books now for several years, have not even been challenged, much less overturned. And the reason is simple. They are constitutional and good policy to boot. And by way of example, after the Oklahoma Amendment was successfully challenged in federal court, Oklahoma passed ALAC, and it was not challenged. It remains a law of Oklahoma protecting every Oklahoma citizen against foreign laws and judgments that would deprive them of their constitutional liberties. In the final analysis, don't believe the lies of Muslim Brotherhood front groups like CAIR when it comes to the passage of laws like ALAC. You can rest assured that CAIR doesn't have the best interests of America or its Constitution, which is grounded in Judeo-Christian values, at heart when it opposes such laws. Stay informed. And you can do so by learning more about the American Freedom Law Center and our fight for your faith and freedom at www.americanfreedomlawcenter.org.